What are the 8 provisions every revocable living trust needs? You're about to find out right now. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, what are the 8 provisions every revocable living trust needs? Okay, so before we start talking about the 8 provisions every revocable living trust needs, I wanted to do a quick recap on why people get revocable living trusts in the first place. Now, many people want to simplify or streamline that whole process of getting their estate settled for their family when they die. Now, when you use a will to distribute assets to your family when you die, upon you passing away, your assets will still be in your name and will be frozen, and the executor or the family members will need to hire lawyers like myself to guide the family through this court-supervised process to have assets transferred from your deceased name to your heirs based on your will. Now, many people perceive that whole probate court process as being very difficult, expensive, time-consuming. In Ohio, the process takes anywhere from 6 to 12 months to get finished, assuming everyone is agreeable and nothing goes wrong. And probate attorney fees, they can cost anywhere up to $10,000 or even $15,000 depending on the estate. So instead of using a will, many people will set up a revocable living trust in order to eliminate all of that probate court and attorney involvement in the settlement of your estate, where they will transfer, the title and ownership of their assets that they own while they're alive. They transfer it out of their name and into the name of the trust before they die. You see, that's because when things are actually titled in the name of your trust when you die, they don't get frozen, which means you don't have to go through that probate court process. You'll likely name a family member to be, the trustee of your trust, so that after you pass away, they can immediately start dispersing things out of your trust to your heirs or beneficiaries without any of that court and attorney involvement. So that's kind of the idea behind the revocable living trust. Now let's jump into the 8 provisions that every revocable living trust needs. Number 1 is to make sure that in your revocable living trust, you state that your trust is actually revocable. This will prevent any confusion as to what type of trust you are creating. Number 2 is you'll want to designate the trustee of your trust. You will name yourself as the trustee, perhaps. If you're married, you'll name yourself and your spouse as co-trustees, and then after one spouse dies, perhaps the surviving spouse will become the sole trustee. It'll also be important to name a successor trustee, since the trust will last for some period of time, most likely after you pass away, because when you pass away and your spouse passes away, your successor trustee will be tasked with distributing the assets out of your trust to your trust beneficiaries that you named to get all of those trust assets. Number 3 is the provision to designate who the income beneficiaries of your trust will be. This means if your trust assets produce some income, whether that's interest income, dividend income, rental income, if you are the income beneficiary of your revocable living trust, which you probably should be, then all of that income goes to you while you are alive. That way, after you retitle all the assets you own in your name to the name of your trust, with you as the income beneficiary and trustee of your trust, you will be able to readily access all your assets and receive all that trust income money and simply file taxes on your personal tax return like normal. Easy peasy. And then maybe you'll have a successor income beneficiary, particularly if you want it to be specific about, who gets the income after you pass away, like your surviving spouse or your kids, etc. Number 4 is who are the principal beneficiaries of the trust. So trusts have 2 different kinds of beneficiaries. I mentioned a moment ago that you should designate yourself as the income beneficiary for the remainder of your life, and then you'll designate your principal beneficiaries, meaning who's going to get the actual trust assets when you die. And maybe you just say, hey, I give the principal of my trust to my children equally. Or maybe you say, I want the cars to go to child number 1 and I want the house to go to child number 2. Or leave a portion of your trust principal to your favorite church or charity. There's really no limit on what you can do here. Number 5 is the trust term. So typically, revocable living trust will get wound up after you and your spouse die, and that successor trustee you named will be in a position to immediately start dispersing assets out of your trust to your children as principal beneficiaries right after you pass away. Occasionally, your revocable living trust will live on after you die, because maybe when you pass away, you have young children that are like 10 years old at the time, and you know that the trust should stay in existence so that they don't get all of their inheritance at that young of an age until maybe they're 25 or 30, and you authorize the successor trustee to only pay for the health, education, maintenance, and support of that child up until he's reached the age of 25 or 30. So oftentimes trusts terminate when the creator of the trust dies, but sometimes they go on for many years after that. Number 6 is adding in a spendthrift clause in the revocable living trust. So what a spendthrift clause says is after you die, assuming your beneficiaries are not immediately given trust assets because they haven't reached a certain age like we were mentioning earlier, then your beneficiaries can't sell or mortgage his or her interest in their trust inheritance, meaning, a creditor of your beneficiary can't seize the beneficiary's interest in the trust inheritance. So having a provision in this trust is absolutely critical. Number 7 is a provision that actually lists out all of the powers and authorities that you are conveying to your trustee to actually carry out your trust. Number 8 is a provision that is not technically an absolute necessity, but it can be very important, and that is a no contest clause. So some people who foresee that there might be internal family conflict and issues when they die due to their children not getting along, or maybe they think that their in-laws, their children's spouses will make things difficult, then we as attorneys will get asked, hey Elliott, is it possible to put a provision in our trust so that if anybody contests anything in court that they'll lose their rights to their inheritance? So see, that's where a no contest clause comes into play, because if anyone legally contests provisions in your estate plan and they lose, then they will lose their right to any inheritance you left for them. So many clients like these no contest clauses as a way to discourage any family conflict after they pass away, since it makes beneficiaries think twice before trying to legally contest the estate plan and cause trouble. All right, in summary, the 8 provisions every revocable living trust needs are as follows. Number 1 is to make sure that in your revocable living trust, you state that your trust is revocable. Number 2 is you'll want to designate the trustee of your trust. Number 3 is to designate the income beneficiaries of your trust. Number 4, who are the principal beneficiaries. Number 5 is the trust term. Number 6 is adding in a spendthrift clause in the revocable living trust. Number 7 is a provision that actually lists out all of the powers and authorities that you are conveying to your trustee to actually carry out your trust. And lastly, while not 100% necessary, but still very important, is having a no contest clause. Are there other important provisions? Sure. But these ones are very important for you to be aware of. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.